The recent ruling by British judges on immigration cases have ignited fierce debate, with critics alleging that the judiciary is too readily influenced by the European Convention on Human Rights and international law, and two cases in particular have drawn significant attention. The decision to allow a Gazan family to remain in the UK under a scheme originally designed for Ukrainian refugees, and the widely ridiculed case involving an Albanian family whose son's dietary preferences became a factor in their legal battle. And these cases exemplify the growing tension between judicial independence, government policy, and public sentiment on immigration. At the heart of the controversy is the ruling by Upper Tribunal Judge Hugo Norton-Taylor, who overturned a Home Office decision and permitted a Gazan family to remain in the UK. And the family, comprising a mother, father and 4 children, has been displaced after an airstrike destroyed their home. Seeking refuge, they applied under the Ukraine family scheme to join the father's brother, a British citizen residing in the UK since 2007. The Home Office initially rejected the application on the grounds that the scheme was exclusively for Ukrainians. A lower-tier immigration tribunal upheld that decision. However, Judge Norton-Taylor reversed the ruling, citing the family's extreme and life-threatening circumstances and arguing that their right to a family life under Article 8 of the ECHR outweighed the public interest in maintaining strict immigration controls. Critics, including GB News, of course, including the GB News commentator Claire Muldoon and political columnist Quentin Letts, have decried the decision as an egregious overreach, suggesting that it undermines the integrity of UK immigration policy. Muldoon described the ruling as a slap in the face to the populist vote and accused judges of folding to international law and the ECHR. The Home Office, echoing these concerns, warned that such decisions risk setting a precedent that could lead to an influx of applications from conflict zones worldwide. The second case, which has been widely mocked, involves an Albanian family whose deportation was halted because of a son's aversion to foreign chicken nuggets. Well, I understand that entirely. While it may sound absurd at face value, the ruling was based on concerns about the child's well-being and adaptation difficulties, which the judge considered significant enough to override the deportation order. Critics argue that cases like this highlight a judicial approach that prioritises individual rights over broader immigration control. But if the individual is not important, then our concept of refugee status is almost irrelevant. This is not about a nation. This is about individuals who need help. Now, these individuals may not merit the sort of help you think they should be given, but they are individuals and they should be judged on individual criteria. The ruling has fueled accusations that Britain's courts lack common sense and that international law is being applied in a manner disconnected from public expectations. But law should not be a popularity contest. Law should not be at the whim of popular sentiment. Law should be impartial. The broader issue at play, therefore, is the role of the judiciary in interpreting immigration law. And while the government insists that immigration policy should be strictly regulated through parliamentary decisions, judges are tasked with considering the human rights implication of each case. And the invocation of Article 8 of the Gazan families case and the application of child welfare considerations in the Albanian case demonstrate the legal framework within which judges operate. From a legal perspective, judges are not creating new immigration policies, but interpreting existing laws, particularly human rights provisions. But critics argue that these interpretations are increasingly expansive and undermine the government's authority in controlling immigration and the government's intention. The problem here, of course, if the government has produced laws which are badly worded and ill-designed, then that is the point of the law. The law tests the laws which are put out by Parliament, and it also tests the laws within the context of international regulations that we're still signatories to. The political backlash has been swift. Chris Philp, the Shadow Home Secretary, has called for changes in human rights law to ensure that Parliament, not the judiciary, dictates immigration policy. There have also been renewed calls for the UK to reassess its relationship with the ECHR, particularly in the light of repeated clashes between government policy and judicial rulings. Keir Starmer has reiterated that the government will uphold international law while seeking a balanced approach to immigration. The Home Office, despite losing these cases, has vowed to contest future claims that do not align with official immigration policies. These cases underscore the ongoing struggle between judicial independence, human rights considerations, and the government's desire to maintain strict immigration controls. While some view judicial rulings as necessary safeguards against arbitrary and harsh immigration policies, others see them as undermining democratic decision-making and enabling loopholes that could lead to an unmanageable influx of migrants. As Britain grapples with the post-Brexit identity and its evolving stance on immigration, the role of the judiciary will remain a focal point of controversy. Whether the government pursues legislative changes or continues contesting decisions case by case, the debate over judicial influence in immigration matters is far from over.